And we're live. Okay, excellent. It is November 1st, and this is a meeting of the Legislative Committee on Judicial Rules. And we're going to get started right away with approval of the minutes of April 14th, 2022, which was emailed to you last week. Are there any questions or comments on that? If not, I would take a motion.
I would so move that we adopt those minutes.
So,
well, during discussion.
yes, all right, and we have a motion from Senator Clarkson to approve the minutes. Is there a second?
Sure.
And Representative Grad seconds. Yeah, and discussion.
So just very technical. We started at 4:30 p.m. and then in the bottom we adjourned at approximately 11:45 a.m. So I think it's just a typo.
All right.
How do we enjoy each other's company?
I completely.
It was a lengthy meeting, if I remember correctly.
It seemed that long.
Thank you. Thanks for the correction.
All right, so any other comments or corrections on the minutes? If not, all those in favor of approving the minutes, say aye.
Aye.
Any opposed? And that is passed. All right, so we'll get to move right on to the rules related to the family rules. And we have Judge Carlson.
He might be remote, I
He
don't.
might be remote, but I don't see that he's remote
I
yet.
was hoping to join, but you never know with his schedule. He's up at the family court in Chittenden, so.
So you're covering Judge
I'm covering-
Davenport? All right, Judge Davenport, thank you so very much.
And Marshall Paul is also with me. He's gonna cover the youthful offender rule. I'll do the other three and then he'll do the youthful offender.
Okay, excellent. So we're going to start with the Vermont Rural Family. Oh, I'm sorry.
No, just question. Mike, what was the date you sent out all the rules so that we can pull them up and follow them?
Yes, let's wait.
I can't remember the date that you,
So the rules are actually hyperlinked in the agenda itself.
okay, and so the agenda you sent, okay, got it.
New agenda yesterday.
Perfect. Even I can figure that out.
Let me know when you're ready. And we'll get started.
Yeah, go for it.
Okay, yes, Judge Davenport. Rule 18D2, I guess we're
Right.
starting.
So Rule 18D2 is, Rule 18 is the family court rule on mediation. The Supreme Court approached the Family Rules Committee, I want to say back in January or February. AO 49 was going to disappear at some point, and it did disappear in September. And AO 49 had specifically allowed family mediation to be remote. And the Supreme Court's question to us was, did we think that Rule 18 should be amended to allow for remote mediation? There had been a the Vermont Bar Association had sent a questionnaire out to their members, asking them about mediation. I'm not sure whether it was sent out just to family court attorneys or whether it went to family and civil. But some of the questions were about remote versus in person. It wasn't very dispositive one way or the other. I think about 30 people responded. Half of them liked remote mediation. The other half preferred in person. But about 65% of them said remote is just as effective as in person. So the Rules Committee decided what they wanted was to make it clear that remote could happen, but not state a preference for either in person or remote. And so that's what this language basically does. The language we added is parties may participate in mediation using remote technology at the discretion of the mediator or by order of the court. And the idea here was the mediator is probably in the best position to assess whether in person is better than remote. So that's all that amendment does.
Fairly straightforward. So I think we're going to see a theme today as well, that a lot of these rules are adopting procedures that were in place under AO 49. And certainly as witnesses are discussing this or reporters are discussing it, If you could let us know how these rules may help as far as the efficiency of the court. Maybe this one is not so much in line with that, but there's been a lot of concern about backlogs in the court, and would love to hear just comments from folks on how these rules may assist us in
Getting on top of
in
this.
getting on top of that. Yeah. So, any questions on Rule 18? I don't see any questions or comments, so I think we're fine with that. Thank you.
Given the backlogs, I'm really glad that Judge Zoning is now in charge. I no longer have that job. So the next one on your agenda, Family Rule, a bunch of technical amendments to Family Rule 2 and 6.1. So there are two reasons for these technical amendments. The first one, which applies to Rule 2, is because the Civil Rules Committee made some changes in terms of motions which basically eliminated Rule 78A, Civil Rule 78A, which was a rule that talked about the courts having a motion day. Well, courts haven't had a motion day in a long time. And so basically that rule had become obsolete. But because of that, we had to make certain amendments in the family rules. And 2A2 is the rule which basically states whether a civil rule is applicable or not applicable. And so it just deletes 78A, and then Rule 3 again refers to a new Rule 7B4, which again deals with motions and makes a small change to that rule, but it's basically a technical amendment. The other technical amendments involve Rule 6, which is representation by attorneys and guardians ad litem for minors, and Rule 6.1, representation by attorneys and guardians ad litem in specified proceedings. These two rules had initially included probate proceedings as well. The Probate Rules Committee decided to adopt its own rule about guardians ad litem. I think their rule is very similar to this rule, but obviously we had to amend this rule so that in probate proceedings, you would use the probate rule versus using the family court rule. So that's really all this amendment does.
That's straightforward. Any questions or comments on these rules?
And the next is Family Rule 9B, an amendment to Family Rule 9B and 9G1. And again, a very technical minor amendment. It is basically, there are certain proceedings in relief from abuse cases where the plaintiff in one case and the defendant in a different case would need to has to give contact information to the court. And this just includes email addresses in the contact information. So again, very minor.
Any questions on this one? No? I think that's good as well.
And then Marshall, if you'd like to do, I'm going to have Marshall Paul, who is on the Family Rules Committee and is basically the author of Rule 1.1 on youthful offenders. Maybe I'll move over here.
Thank you.
Hello, everyone.
Morning.
So Rule 1.1 is a little different than the others. This is not a pandemic rule, and it's not sort of merely technical. This is a rule that essentially captures all of the changes to youthful offender law that have been made essentially in 2017, 2019, and 2020. And at this point, the youthful offender law is being used enough that it seemed to warrant its own rule. So if you're familiar with the family rules, we have Family Rule 1, which deals with delinquency proceedings, Family Rule 2, which deals with CHINS proceedings, Family Rule 3 deals with termination of parental rights, and so on. This would be Rule 1.1 because it fits most closely with the delinquency rule, but is separate from the delinquency rule, and so we figured should not simply be a subsection under delinquency. I'm not going to read the whole rule, but I'll sort of walk through it in general steps. But before I do, I just want to say that this is a really straightforward rule because of the way that the youthful offender statutes are written. They're written very prescriptively, which is always a really good thing in the juvenile docket, especially to have really clear procedural rules. But it did make it so that drafting this was really straightforward and doesn't involve much in the way of interpretation at all. This essentially just sort of organized, while the statutes are organized sort of by subject, the procedure is organized chronologically through the procedure of a case. And that's really what this does. So it starts out by saying that in general, except for everything which follows and makes sort of changes to Rule 1, that Rule 1, the delinquency rule, applies to youthful offender cases. And then Section B is the preliminary proceedings, which really consist of three things, which is a risk screening notification, which is where the youth is notified that they need to attend a risk screening provided either by DCF or a community partner. Then that risk screening results in a report, which is filed with the court, and that bail and conditions of release are still handled in the criminal division because these are cases that generally transfer from the criminal division to the family division. And until they're all fully accepted in the family division, the criminal division still has control of the case for purposes of doing bail and conditions of release. Then it moves on to the hearing. This would be the consideration hearing to determine whether somebody is eligible for youthful offender status. And it's just very simply says that, establishes the evidentiary rules that if these are contested, the rules of evidence apply except for the rule on hearsay. Hearsay is allowed as long as it's reliable. And just establishes that the court must engage in a colloquy with the youth because the youth, in order to get youthful offender status, has to waive a couple of constitutional rights, and making clear that that has to happen personally as a colloquy between the judge and the youth. Statutory requirements, again, is requiring that the youth get notification of collateral consequences. Actually something that applies in every delinquency and criminal proceeding as well, so it's no surprise that that applies in youthful offender. And then the adjudication hearing, which just sort of establishes that if youthful offender status is granted, then the case remains in the juvenile division. And if youthful offender status is not granted, then the case is transferred back to the criminal division. Then Section F is modification and revocation, which just establishes what you do in the event of a violation of probation. And that's, again, this is all explained in much more detail in the statutes, but this just sort of is the chronological guide through the statutes. Then establishing what events trigger the closure of probation, which is in the youthful offender case, that's the end of the case, is when at the termination of probation. And explaining that that's the close of the case is subsection H. The reporter's notes in this one are stupendous because they go right to the statutes and tie every rule directly to the statute that sort of, in this case, normally you would say what the statute that the rule is interpreting, but there's so little interpretation here that it's more the statute that the rule is capturing. And I'll take any questions.
Thank you. I'm just curious, given how are there any adaptations with for youthful offenders with the risk screening? How does that risk screening differ from an adult?
So it's actually specifically designed for youth. It's called the YASI. It's the youth, I'm going to mess this up, Youth Assessment Screening Instrument. It's developed, and in fact, it's the Youth Assessment Screening Instrument. I'm not going to say where it was developed because I thought I was remembering that it was in Massachusetts, but now I'm just having an inkling that maybe I'm wrong about that. Ohio. It was developed in Ohio. It's used in Massachusetts. It's used in Vermont. It's used in a number of states. It's normed up to age 21, and it is It's a good tool in my mind, in part because it's in continuous, I don't know what you call it, but development. They're constantly taking the data and feeding it back into the tool and making it more and more accurate. So what it is it's actually a series of about 40 questions, some of which have to be answered through an interview with the youth, some of which are objective criteria and are answered just by looking back at the youth's criminal history or juvenile history or so some of it's subjective, some of it's objective. Each element of it is scored, and then it goes into a little bit of a black box computer because this is all proprietary stuff. So we don't actually know. We know what the input is, we know what the output is. We don't know what happens inside the black box, but that returns a score that is based that establishes the youth's risks and needs, and in our experience as defense attorneys, it's actually been a really valuable tool. It has identified a lot of kids who might appear, just based on people's sort of preconceived notions, to be high risk, but actually, when you look at the statistics and the data, they're not actually high risk. They might do some things that trigger people to perceive them as high risk, but that's different than actually being high risk. And it's these kind of actuarial tools that do a really good job of sort of identifying those kids and allowing judges and prosecutors the opportunity to make decisions based on that information. The risk screening tool in Vermont is not used in any kind of dispositive way. It's not like you can, say, oh, my child scored low on the risk, low risk, therefore they're entitled to diversion, nor can you say, oh, this kid scored high on the risk screening tool and therefore they must go to criminal court. There is no sort of must about it. It's just a piece of evidence that is used in court and that the judge can consider for what it's worth.
Thanks.
Other questions? So I did have one question. So in subsection B2, I'm wondering, usual for a rule to be ordering an executive branch agency, here the DCF, to do something? I know that we can certainly in the legislation, but this rule is mandating that DCF provide something at a particular time. And I'm wondering if that's unusual or if that's appropriate for that to be done in a judicial rule. I don't know if you have the answer to that, but that's one concern that I would like to have addressed. And maybe it's not a concern, I don't know, but.
It certainly did not raise any red flags. DCF's AAG was part of drafting this rule, was on the subcommittee that drafted this rule, and they didn't raise any concerns about it. I'm just thinking through, I know that we have other rules where executive agencies, law enforcement are directed to provide information to, for example, defense attorneys.
I think the other part of that is, this is what the statute says. So it simply is parroting what you all decided, that DCF would be responsible for doing this and would have to do it in a certain number of days. It's what the statute says.
I understand, yeah, but the statute is the legislature is telling the executive branch to do something, which is obviously fully within our purview, and this is a judicial rule, and that's where my concern is. And I don't know if, Eric, if this is something you've dealt with in the past, or is this really a concern at all that I should have, or?
I don't recall it coming up before, actually, so it's an interesting question, and I off the top of my head, I'm not thinking of any prior instances where it's been discussed in committee, so I think it's a legitimate question, one to ponder, but I don't have an answer off the top of my head.
I mean, is that something we can look into, before the next meeting, or how should we deal with that issue since?
I think at this point, if I'm reading correctly, it's scheduled to go into effect in a few days or a couple of weeks, right? So at this point in time, you're still in the 60-day objection window. So the formal option for the committee is to object. But if you didn't feel like that was a step you wanted to take, then it's certainly something that we could look at prior to the committee's next meeting, just for informational purposes. And
yeah, I don't know enough to object necessarily. It's just raising this as a concern. What's the wish of the rest of the committee?
Did the underlying statute direct judiciary to create the rule?
It did, I could read from the statute. So the
Popping
statute,
that out of my head, I'm thinking, I'm not necessarily as concerned,
Okay.
but that's just me.
would it help if I read the statute, the statutory language?
Yeah, as far as the rulemaking, yes, because I think this does, the section B2 definitely follows the statute, but yeah.
So it's from section 33 VSA 5282 subsection A, is within 30 days after the youth has completed the risk and needs screening pursuant to section 5280 of this title, unless the court extends the period for good cause shown or the state's attorney refers the youth directly to court diversion pursuant to subsection 5280E of this title, the Department of Children and Families shall file a report with the Family Division of the Superior Court. And then in subsection B, it goes on to detail what needs to be in that report.
But I think there's also, to Senator Benning's point, I think there's also language at the end of the youthful offender statute that said, that directed the judiciary to do rules.
Yes.
That often is true.
Yes, I don't remember, I don't know if that's in statute or if that was in session law.
Yeah, it's in
It's probably session law.
It's in session law. All right, well, I suppose if we look into this further down the road, we can request an amendment to the rule if we really see this as a big problem.
Yep, absolutely.
So I think we'll not have any objection at this point.
All right.
All right, thank you.
Thank you very much.
I believe Judge Morris is up next.
Yeah.
I don't know if it's called pinch hitting for Judge Treadwell or you're the main hitter anyway. You're the leadoff batter.
Well, yeah, we've communicated, and based on recent proceedings down in Windsor, since we last spoke, I'm not surprised that he's not joining. He said he would join if he could.
Great.
So here I am.
All right, so we're looking at the rules of criminal procedure, and we're starting with Rule 11A4, which became effective June 20th. Over to you, Judge Morris.
This is what I'm going to, a long Benning amendment, because as you'll remember, this amendment dates more recently, but it followed another amendment that came from a court case, an appellate decision, Benoit, which expressed concern about how someone might preserve an objection in the case of an enhanced offense. Simplest example, DUI 3, a felony. You have to show that there's a 2 and a 1 in a valid conviction. So in order to preserve a challenge post-conviction to the validity of those predicate offenses, the defendant would have to say, okay, I'm going to have a trial, even though the only thing I'm fighting about is whether I have a conviction of 1 or 2 to begin with. And generally, those issues are associated with having had counsel or not, the court's inquiry under Rule 11 as to the validity of the plea and any defects in that. So case law had said you got to have basically a trial in order to preserve that objection. And in wisdom, it's basically, it doesn't make any sense to force a trial if there's an avenue for preservation, clearly, without surprise to the prosecution or the court. I'm going to have a post-conviction challenge. I'll plead guilty today, and if I lose that post-conviction, I know I stand convicted and with the sentence I'm pleading to today. So that was 11A3, a plea agreement. And in the course of our presentation of that 11A3 amendment, the two esteemed gentlemen there, you guys said, why should we bar a defendant who simply doesn't have the benefit of a plea agreement from doing the same thing? So we took it to our committee and said, good idea. As long as there can be clarity as to, look, you're pleading straight up. This is without a plea agreement at all. So there's no risk of blindsiding or undercutting the prosecution or the court in terms of their expectations. And so that's basically the rule that we've had in place. It's been effective since the summer. We've heard nothing about its use or not, but heard in the process from our committee members that this was absolutely a good thing to do. Sometimes you just have loggerheads as to a plea agreement. You can't reach a total agreement. it leaves some ambiguity about the inquiry the court makes about the expectations of the defendant. And those are not prescribed in the rule, which just authorizes this procedure. So I would assume that the presiding judge would want to make it extremely clear to the defendant, you're pleading without the benefit of a plea agreement and all that that means. You could receive the maximum, but I'll hear what you want me to order as a sentence. But do you understand that by pleading today, you're going to be bound by this conviction? And the only condition would be that if you succeed on a post-conviction as to the predicate. That's an important point. This only applies in cases where there are enhanced sentences based on predicate convictions. So it's not generally a rule of application. That's it.
Any questions on this?
11A4.
Great, thank you very much. Thank you for that change as well.
Thank you for bringing it up.
So we'll move on to then Rule 45A for A and E, which became effective September 6th.
Yeah, and that one is what I will describe. The only presentation is another technical amendment. Rule 45 is the criminal rules version of the time, I'll call them the time package, how we calculate time in the various units. The civil rule equivalent is Rule 6. And these are all virtually identical. You have Civil Rule 6, there's a Probate Rule 6, and then there's our Criminal 45. This rule does two things, and it follows what's already been done with regard to the civil rules. It eliminates what was a 3-day extension period following deadline for filing a response to a motion. This was in response to movement to Odyssey electronic filing. And basically, the perception that there's no longer a need for this lag time because you're not waiting on the mails, it's electronic. So it parrots the civil rule that's already been in place. The other thing it does is consistent with, I guess it is a bit of an AO 49 change, which is to permit or authorize emailing to be done by essentially self-representatives. Lawyers are bound to do emailing unless there's a specified exception. The vast majority of self-representatives, unless they choose to engage in e-filing, don't have to. So the rules authorize emailing by that population as a mode of filing and service. And this tail ends and just says that if you file by email, as a matter of time, you still get the midnight deadline that's applicable to electronic filing. That's all that it does. So this is what I would call a technical amendment that follows identically with Rule 6.
Pretty straightforward. Yes. Senator.
But you did bring up the subject of e-filing. So for those of us who've been very concerned over the last 3 years, are you able to give us an update on where we are with how it's doing? Or maybe Thomas here.
So
the other Thomas.
Well, I'm actually the reporter for the Committee on Rules for Electronic Filing. Okay, and
I ask you with purpose. No, I know.
The chair is Justice Dooley, who is not here.
Who is not here. But it's been a concern of this committee for a long time.
Well, I understand. I've been here for the meetings in which that's been discussed. I can just say this: there's been a newly comprised permanent standing committee on e-filing. The order of appointment was made just about 2 weeks ago. And last Friday, we had our first meeting of that newly comprised Committee on Electronic Filing. It was a special committee, an ad hoc committee that was supposed to sunset once a set of rules were out. And we just kept going. The constituencies represented are expanded to have a designee of the Defender General's Office, a designee of the state's attorneys and sheriffs. We do have a VBA representative. We've always had one. Trying to think of scanning in my mind the
Legal aid.
Oh yeah, Vermont Legal Aid is represented. Eric Abelson, who's now retired, is now been the new executive director, is a member. The court was mindful of the need to have those constituencies, particularly Vermont Legal Aid and the prosecution defense at the table. Jordana Levine is the Defender General's representative, and she's been very constructive and proactive in commenting about any defects. And I don't know, the state's attorney's representative, Stephen Brown, I think he's Deputy State's Attorney in Wyndham, where Stacy Kelly Schreiber is the State's Attorney down there. Who also has been quite vocal about.
She has.
Yes, historically. So I guess I would say, as the reporter, not the policy guy, we have moved into a post-promulgation, post-use period of picking up pieces that might need tinkering with. And this is really a report on electronic filing. At the meeting last Friday, we're looking at the screening process. There's a Rule 5. This is electronic filing now I'm talking about. Rule 5 deals with this filing and screening process by court staff and the acceptance or rejection of an e-filing. And that's been something that's flared up some views about. And right now there are basically two standards in the rule. The clerk looks at the filing to see that the rules of public access are complied with so that non-confidential information by law is not inadvertently filed on the public side. And then the clerks look at a very general provision. Are all of the other provisions of the rules being complied with? It's very general. So the committee last Friday in our discussions discerned the need to see about whether we could specify what the court staff's going to look at and what would be a basis for rejection beyond those two existing criteria. To go further, Laura LaRosa of the court administrator's office is on this, and she has, in the course of the discussion, indicated that there's 18 criteria that the screening staff look at. Some of these are driven by the rule. Many of them are driven by the public access rules. And some are driven simply by the technology. You know, the system just won't accept this if you don't have a case number or you haven't given this element of data. So we're looking to schedule another meeting in the next few weeks, 3-4 weeks, to have the committee back to say, should we look at Rule 5 in terms of the things that can be the basis for rejection of a filing, those that must be in there to warrant acceptance. So we're trying to work on that. That's one issue. We have another issue regarding to paper filing of wills. You haven't seen that yet because we're working with probate on their requirement under the state will registry to actually receive people's paper wills. So we got to reconcile the electronic filing rules with permission and what's covered by the non-electronic side. And what happens when you get all this paper in when we're supposed to be moving away from it. So that's a long roundabout to say electronic filing is in a post-promulgation phase where most of it is working and we're not hearing the kind of big issues that we're together we talked about. So it's this, I hesitate to say smaller because every time I say it's smaller, minor, little, it isn't so. And
So the thorniest issues have been worked out.
I said preponderance of the thorny issues have been worked out, such as, you know, the fees and all of that, which was discussed.
Its functionality was a big one.
Yeah. And there's I would say this much. I know there's been pretty vast improvement in terms of the focus of court administration on that very subject. They've comprised a team, technology team that's been very responsive, very knowledgeable, at least to my inquiries. Marcia Shells, who's got time in state government elsewhere in tech, is the tech head now for the judiciary. So they're working on it.
Progress was needed, so that's good.
Yeah.
Senator Hinsdale?
Senator Ron.
Have you looked at language translation in this area?
Well, this is for filing.
Yeah. I saw service as well, which should be in other languages.
Well, I know that's an initiative of the judiciary, and there is staff working on interpretation and translation, not so much, but interpretation, which is a huge issue, of course, in the live proceedings.
But documents.
Yeah, I hear what you're saying. I don't know the answer to that, but I would presume that there is somebody looking at that as it relates to electronic filing. Everyone's entitled to elect to electronically file, and if they have a language challenge to have that be accommodated. The vast majority of electronic filers are attorneys who are required to. It's a smaller population, but your question is well put. So.
Do you have a question?
Is there any conversation about the case number itself back to a docket as opposed to a number that doesn't tell me what county we're in, doesn't tell me what month or year it was filed? Well, it does tell me the year, that's right. But
not much else.
that information in the old docket numbers was actually critical for those of us who are practicing and could tell where our cases were going to fall on a given trial schedule.
Yeah, to my knowledge, no. Your question prompts me to add it to our next agenda, and we'll talk about that. That seems to me to be a tech matter. In other words, will Odyssey File and Serve, our version, except other than that, is it within our power to alter software, or is it something that has to come from Tyler Technologies?
Well, the other component of that is the old docket number. I don't care how you plug it in, it doesn't work.
Okay.
Unless you have access, this is a whole nother story, to a given case, like you're the designated party.
Right.
If you go into the portal, it's also problematic, but.
All right, so
My biggest beef is with the docket and case numbers not being.
I guarantee you it'll be on our agenda. Just to understand a little further, are you searching for case by name and not getting there?
You have to go by name.
Case name, right.
But there are times, if you go into portal, you plug in the person's name and the docket that you're working on does not show up. I don't know what that problem is. It's probably nothing to do with what you're working on now, which is Tyler specifically, but.
Well, it's a tech issue to be passed through because we have our tech people on electronic filing.
There are times when I'm assigned a case, I can't get in. So I call the clerk, and apparently the clerk has forgotten to hit some toggle switch somewhere that enables me to have access. I don't understand what that process is, but that's another frustration. My biggest beef is still with the case number not giving me the information that the old docket numbers used to have.
I hear you. We'll have that on for discussion. Maybe if it's okay, I can follow up with you about the specifics of that, trying to find a case.
Sure.
Thank you. Yeah.
So we're going to get back to criminal rules. And I think for future, we'll have an agenda item every time on our more recent complaints about electronic filing rules.
And it's progress. I mean, we want to be positive.
I'm sorry, the progress. Of course, that's how we'll term it, future agendas, but.
I'm happy to answer any of these questions. Of course, I have no problem. And the worst that can be done is to ignore someone and what they're working on, right?
Right.
So you're paying attention. How good is that?
No, I appreciate it. So no other questions on Rule 45. We'll move on to Rule 26.
26.2. This is a rule that the Criminal Rules Committee has been working on for about 5 years now. It had a limited focus to begin with, which was in those cases at basically a trial or a hearing where the defendant had the right to be present. Could we not have a rule that addresses how the parties could agree? We're going to have this witness come in by video or by audio even for this limited purpose because they're a chemist in Issaquah, Washington, and I need him and I can't get her or him here without $10,000. And it's basically the science and the parties agree, okay, we'll let that happen. Or a chain of custody where an officer is now in another state and that evidence needs to be presented. So it had that limited focus. And, in civil side, this has been happening forever. You have videotaped depositions offered at a personal injury trial. Everybody's knowledgeable and happy. We have an issue drawn from the Sixth Amendment right of confrontation of defendants. They have a right, as we know, to be present with the witness, to be present with the trier of fact making the decision, whether it's jury or judge, and to be able to confront that witness. That right can be waived, but it's tricky. When is the waiver given, the agreement to have that happen? If the defendant changes their mind between the time of agreeing, yes, you can have that witness, the jury's sitting there, now I changed my mind, I want that witness here. So this rule had a narrow focus where the parties agreed, where the defendant was present, trial, or in another evidentiary hearing where presence would have been required, confrontation required. So the rule sought to do, I'd say at least three, if not four things. First, it authorized this procedure for agreement, testimony of a witness remotely by agreement. Second, it established standards for that testimony. The witness be in a suitable location, not in their backyard, not in a courthouse, courtroom, public building, suitable. There would be inquiry as to who would be present with that witness from the remote location to make sure they were not being prompted or influenced or dissuaded in any way. There would be standards for the judge to look at before approving of that. And if we all agreed, here's who can be with the witness, here's who cannot be, and here's how we're going to proceed. So that's the standards. The rule also says the judge has to engage in a colloquy with the defendant about the giving up, not of all confrontation rights, but the right to the physical presence of the witness testifying. So they still have, of course, the right to be present, to see and hear, to have the jury see and hear in the same time as the finder of fact and the defendant, and everyone were present. The colloquy is not entirely prescribed like a Rule 11 plea colloquy. It's fairly lengthy with the rules saying most, but not all, of what the judge has to inquire about. The basics are that the judge has to inquire, has the defendant had the help of a lawyer in making this decision? Do they know it's their decision, not the lawyer's decision to make? Do they understand that if they do agree to this, they're giving up any right essentially to later claim that their confrontation right was violated? The right to the presence of the witness was violated. It's quite clear you can't force this over a defendant's objection. We have a case that's cited in the reporter's note, Triple, where a lawyer had said, okay, we'll agree to this. And the defendant said, I don't know that I agree to that. And the judge went ahead, and it's like, this is the defendant's right. So it's quite clear we can't crack a rule or even a statute that says you can bowl over a defendant's right, confrontation rights. So a colloquy about the consequences and whether you've had counsel. And then the rule sets standards, as I've said, for the taking of the testimony. And then finally, the rule deals with a very difficult question. You've had a procedure where the defendant has waived the right to physical presence and agreed to that witness to testify remotely. You then have your jury selected and you got your trial. The jury's sworn in. The defendant tugs his counsel and says, I don't agree with this. What do you do now? The jury's sitting here. We've relied on that agreement and representation. The analogous rule to this is where a defendant seeks to withdraw their plea to a charge. It happens a lot in sexual assault cases. Plea, waiting for a PSI. I want my trial now, So that rule, Rule 32, the criminal rules, sets forth criteria and standards for when and under what standard a defendant can withdraw their plea. This rule has a set of guidelines expressed in it as well for the judge to consider in whether to grant or deny a request to withdraw from the agreement. As you can see, there can be great prejudice to the state and misunderstanding on the part of the court, reliance on that, and summoning a jury. At least it's an inefficient process that should not prevent, and the rule authorizes, of course, the judge to grant the request to withdraw from the agreement. We have to have that as an option, always. But basically, it says these are the criteria to be considered in making that very difficult decision. Among the criteria for granting or denying a request to withdraw from the agreement for video is, what's that witness going to testify about? And is it in the course of the trial, what's the impact of denying a request to withdraw from that witness being able to testify? How prejudicial is the evidence? Is it custodial? Yes, I was at the crime scene, I picked up this box, I marked it as A, and I put it in the file. Or is it key testimony of a witness as to what did or didn't happen? So those things are to be weighed by the court. The idea was to allow the parties to agree, that's the key word, agree, not be told by the judge, this is what's going to happen here, because it's cheaper. Parties can agree that it's in wisdom the best thing to do for our trial, and to allow the court to accept that and what standards are to be guided. And we've worked on this for about 5 years. And it was apart from IUGA COVID land, and it was apart from AO 49 and the changes that authorized certain proceedings to be remote. Throughout AO 49, anything the court said about presence of the defendant was basically agreement and waiver of presence. So that is, I think, reflected in what we've done in this rule. But coming out of AO 49, we don't know exactly the tenure or texture of the others of the civil rules on remote proceedings. There's a legitimate debate. What will our criminal courtroom look like in the future coming out of AO 49 and the remote proceedings that were authorized? Both sides in criminal land are saying, you know, a lot of this stuff, yes, we like it. It prevents assigned counsel that have 4 contracts in 4 different counties from having to drive all around. We can focus and appear remotely for a status conference or any other discussion that's not dispositive of the case. Even some that are, where the defendant says, look, I'm sitting here. You got a plea agreement. I want to go ahead with it because I know what I'll be looking at if we do this remotely, and I just want to get it over with. So there's a direction here that kind of has good things, kind of has us going like, what will justice look like? What will criminal court look like going forward? So these are things we're all going to be thinking about. This rule, I would suggest, is narrowly tailored to testimony by agreement, which is basically accepted by the judge under criteria. It provides relief for the defendant if there is a change, but criteria that guide the court in either denying or granting a request. That's a difficult, especially in the case backlog situation. If we've got a jury ready, relying on certain fundamental predicates as to how the trial's going to go, including witnesses, that's a huge disruption all around. Yet we have to be considerate of legitimate and fair reason for withdrawing. So the status of this, it's been published for comment. We received one comment about the presence of the defendant, which really is not affected at all by the rule. And just yesterday, Judge Tomasi sent me a few comments that make sense to me that we're going to pass on. Oh, there you are, Judge Tomasi. He sent me a few comments just yesterday about how the rule could be clarified. And so this will be back to the Criminal Rules Committee on December 2nd, which is the date of our next meeting. So we're still working on this one, and we will be back to you necessarily before any promulgation happens. That's my view.
Yeah, and I think that we're going to have hear from the state's attorneys, Department of State's attorneys in a moment about perhaps some other concerns, so that you can hopefully take back on December 3rd as well. Mm-hmm. But any questions initially? No questions? Yes. Sorry.
I just want to make sure I understand. I mean, this is coming up in a bigger way because now video conferencing is available. Is there a separate provision or discussion considering safety or well-being of a witness, somebody who may have been the victim of violence, who doesn't want to be sitting in the courtroom? Is that ever a consideration that comes up?
Well, I think it's quite often a concern that has to be addressed by the state's attorneys. Yeah. Quite often, as we know. In terms of remote presence, in criminal practice, it comes to trial, you've still got the Sixth Amendment confrontation right.
Right.
And there are rules that authorize certain vulnerable, like children or disabled, to use not the quite artful word, to have alternative testimony given on a finding of trauma and trauma that would be result from the person's direct confrontation with the defendant. Rule 807, I think it is, for remote video testimony.
Okay.
in other contexts. I think it's a matter of the state choosing when they need to have a live witness, that is the victim testifying in any capacity. One flashpoint that they may provide you a better perspective on would be where on a 12D, a motion to dismiss for lack of prima facie case. Evidence can be considered, although the standard is considering the state's evidence in the light most favorable to the state, excluding any modifying evidence. There can be dispute as to whether the state could rely on an affidavit of a victim in support of their case. And I think it's clear that that can happen because of the way the rule is read. Testimony affidavits or sworn statements can be relied upon. But there are efforts to seek testimony of victims at a 12D.
But just to clarify, the decision has been made that the right to face your accuser has to happen in person. Like that's the.
Unless that is waived by the defendant.
Okay. I mean, I just don't think that part is written in, it just says you're facing the accused and why that doesn't count digitally. Sounds like it's been a lot of discussion.
It's our Sixth Amendment origin, and so far, no jurisdiction has approved of a court ordering that over objection of a defendant. No court has ordered that a witness may appear remotely over the objection of a defendant because of that component of confrontation, which deals with the physical presence of the witness.
Okay.
And back to your point, Senator Rahm, I thought, this is on the realm of what is the future of our justice system going to look like? And there's a lot of views around what that should be. And, what we hear is that it's convenient to do remote and video for a lot of reasons, but are there any pause stops here when it comes to the fundamentals? There's another, I'm tempted to go on a lot. Confrontation is based on Sixth Amendment, which deals basically with the trial. And it's been extended to those proceedings that are necessarily connected to the trial. And so, for example, a suppression hearing where witnesses are testifying, or the sentencing, critical phase of a trial. But beyond that, there's some dispute about whether that's a Sixth Amendment right of confrontation or whether it's due process fairness, which requires presence. So, and there's some cases on that, but that's a longer discussion.
So I just had one comment and one probably high-level question. The comment just with respect to there's subsection E, the party having to coordinate the technology. I certainly would hope that the courts can really look at making sure that they have the technology available in all courtrooms to be able to accommodate this kind of thing because it seems to be efficient. So that's more of a comment than anything.
Right. The tail end includes a reference to an administrative order which deals with the technical specifications of the recording.
Yep.
The other thing I'd say there, Mr. Chair, is that I think the rule says that the court facilities may be used. That was added as we went along.
Right. And I'm just hoping that for the courts make sure that those facilities are available in all the courts. My question has to do really, it's at the end of the comment, it talks about AO 49 and clarifying that in non-evidentiary proceedings in criminal division, a judge may preside remotely and require others to do so. And I'm wondering if there's any rule on the horizon that may make something like that more permanent?
There's presently a special advisory committee on remote proceedings that's been meeting for over a year. And
so that may be something coming down the pike.
Yes, yeah, it's by no means like imminent or anything like that.
Right, okay. All right, thank you. So we're going to hear from the Department of State's attorney, I think, Timothy Reuters-Duma, is that right? Yeah, if we could.
Is that on 26.2?
Yeah, 26.
Yep.
And
I think you need to sit here, Tim.
I wouldn't want to excuse you here.
No, you're the witness, right?
Well,
Judge Morris provided an excellent, many of the points I think we're going to bring up, he actually clarified in some way some of our concerns and tailing off of Senator Ron Hinsdale's comments about victims of crime. But we did solicit some input from some of the state's attorneys, and sometimes we don't get much of a reaction, and sometimes we do. There was also a transition on who our appointees were on some of these committees, so we really appreciate the time. Just briefly, Mr. Chair, one, the rule of evidence that applies to individuals with disabilities and children under the age of 12 is Rule 807, and it provides certain circumstances that Judge Morris was just talking about where they can appear remotely, and it often is in the sexual abuse context. And so that is provided for. And so a suggestion to the committee would be, to expressly put subject to 807. A couple of our state's attorneys noted that they thought that might be really helpful if there was ever a dispute in court about, which rule trumps which rule. That way they're self-referencing. So a reference to 807 would be very helpful. It also addresses individuals sometimes at sentencings who have been victim to a crime, or sometimes in a position where they can't physically get to the courthouse, sometimes because of the interaction with criminal conduct. So someone who's in their bed and they can't leave their house, a consideration for the committee would be that would be an exceptional circumstance where they can't get to any courthouse or any acceptable, suitable place, and that doing it remotely from their home, perhaps with someone agreed upon to observe, a court employee or a neutral party, might be helpful. WebEx has been an incredible tool for people, both defendants, families, victims across the spectrum, to appear remotely, and a little bit of a wiggle room there would be helpful for some victims of crimes and their families. In a sentencing, some individuals might be wanting to talk and they're from across the country. I think that's more of an agreement type of situation potentially. But certainly we've seen circumstances where the inability to get to any courthouse would be an obstacle. So I did want to flag that. Another point of reference, it only applies to trials and what are called violation of probation merits hearings. I think we have less concerns because those are those, point in the road where there's a live testimony, either with the judge or with the jury and the triers of fact listening. But I, for example, have been told by a judge that we're doing the VOP merits, the violation of merits tomorrow. We do the arraignment, we're doing it tomorrow, or we're doing it in 3 days. So the 14-day window, I think, at least in practice, sometimes can be very difficult to comply with, even if you have an agreement of the parties. So ideally, you have that. But for sentencings, for things like that, when there's a longer ramp up for major felony, for example, I think it's easier to have some of these discussions. But for the fast flowing, or you have a pretrial conference on the 1st of the month, the 3rd of the month, you're picking the jury, the 5th of the month, you're having the trial. So that 14-day window, when you have 50 cases on for final pretrial, you may not be able to let all of your potential victims or witnesses know that are not present. What I typically did when I was a deputy state's attorney here was I would try to send out a note to everyone that could possibly be called. But I know with the caseloads where they're at across the state, sometimes that can be an obstacle, a practical obstacle. The other thing I wanted to note was in 26.2 F1, and that's where it talks about the other suitable place. I think that's probably kind of a technical conversation, but what that might look like in those circumstances where someone can't leave their home. But certainly that type of exception would be great. So that was the specific reference, 26.2 F1. F2 is about who is with the person testifying. And in that circumstance, we would love to have the victim advocates have the ability to be present. For people of all ages, we find that, it's that level of comfort. They've sometimes worked with them for years, and having another person there, making sure that the victim advocate is not doing anything untoward is certainly fine, but they're well trained. And it could actually be a part of something that we train victim advocates on. If you are in a situation where you're with an individual who's testifying remotely, your presence might be okay, but nothing beyond that. And they know that from the trial experiences that they all have.
Before you go on.
Yeah, no, Tim, if they were in court, they'd be there.
That's true. That's correct.
So that makes sense.
Yep.
I mean, my mind, it makes sense.
And, you know, I think that's really the extent. There was some concerns, and, you know, I'm thinking about sentencing hearings where sometimes it is, the trial has happened, the PSI, for example, in a felony has happened, and the victims' families, who, by the way, may not have full agreement with the way the state's attorneys, you know, performed, or the defense attorneys, or the court, or the judge. The ability to have those folks have their voices heard, I think is important. And, you know, I think Judge Morris had provided a good understanding of when the confrontation clause really comes into play and a longer discussion. But, we've seen that happen in a sort of ad hoc fashion, you know, in the courtroom hallway. Are you okay with their mother calling in from Massachusetts? And yeah, that's fine. And without the sort of formality, and I understand there's a need for it as well. But I wanted to bring a couple practical points that we've seen play out.
Appreciate that. So, yes, Senator.
So just because I feel like the world of video recording is new in general, I have been part of cases where the witness or the victim is very worried about the defendant having a recording of the video afterwards. Is that standard? Can the defendant access the recording and keep it of a witness testifying? Stalking cases, this is frightening for people.
I was thinking of stalking cases as well. And, I'm not sure their ability to access it. Judge Morris or Judge Tomasi might have a better understanding of that, but we've had stalking cases where the case has effectively not happened because the individual will not come to the suppression hearing, to the motion to dismiss hearing, the suppression hearing, and the ability to negotiate video didn't take place or couldn't take place, and there wasn't an agreement. The case kind of ends at that point. I mean, it certainly is, in terms of the future of the courts, I think it's certainly a point of concern in those stalking cases.
There's Criminal Rule 53, which deals with recording devices in court, and generally a participant or a party themselves would not be able to record the proceedings. There's an official record of the case, which is the audio of the case.
Okay.
And the judge has authority under that rule, and there's an equivalent civil rule regarding recording, I think 79.1 or 2, which says the court can issue protective orders as necessary.
Okay.
Yeah, in criminal, it's long been a concern that a witness in a case will be somehow surreptitiously videoed.
Right.
And then harm done on the outside as a result of that.
Yeah, I was thinking of a case in Superior Court I dealt with where the court in 24 hours gave the video of a stalking victim to the person being accused and notify them.
Well, I think access to view a video, first of all, I don't think we have any video records. Oh, we do, under WebEx, don't we? Yeah. Well, that's not the official record, right? The official record remains audio.
Yeah.
WebEx recordings are there, but they're not considered part of the record.
Okay.
And in some cases, the judge may turn off the WebEx if the trial has everyone in person and they're up to them. Yeah.
Okay.
Right.
So I assume we don't need any kind of motion or anything like that. You've heard these various concerns and will be taken back to the committee since it's still be a work in progress.
They did come in at sort of at the last moment, so I'm happy to spell out any of them in further writing. Thank you all so much for a few minutes today.
Thank you. Thank you.
And welcome to the.
Thank you, Senator.
Just as we take a pause, Mr. Chair, I have to leave at 11:30 for a task force across the hall.
Okay.
Well, Lisa
So we'll try not to have any motions after 11.
Okay.
So we are running a little bit late, so we're jumping to the next rule and Rule 24D. And if I was listening to my audio book, I'd put it to 1.5 as far as the speed. And,
Okay. The Rule 20.
78 to speed it up.
That's old school.
That's what's old is new again.
This is true, plastic vinyl. Rule 24 amendment carries forward the provisions that existed under AO 49 that allows the judge to seat more than 4 alternate jurors. And the idea there is that COVID has taught us that
we need for various reasons, including health. So, be able to seat more than 4 alternate jurors. That's what this amendment does. And it also prescribes how you count additional peremptory challenges when you go up beyond 14 seated jurors. And that's all set.
Yeah, this one's pretty straightforward, and it seems to be one that will help us be a little more efficient in getting trials.
Right.
So,
And if anybody's wondering, then will you now be seating 24 jurors for every trial? The reporter's note says that's not contemplated. It's in the reasonable circumstances related to the case. So.
appreciate it. Any questions? Yes.
And that's just for COVID cases?
No, it's going to be out of AO 49 and COVID. The court perceives the need to continue that provision that allows more flexibility to seat. Instead of seating at most, it would be 16 jurors, like in a murder case or sexual assault that's going to go long. The judge could seat any number of additional jurors reasonably related. There's no cap on it. But in my experience, nobody's going to seat more than are necessary given the length of the case and its complexity and the health conditions in the community. So, yeah, so it just gives us that flexibility.
Sure.
You could have 14 and then 3 go out for illness and you don't have a 12-person jury.
Right.
So,
Okay, thank you very much.
thank you all.
Thank you.
Always great, and especially the electronic filing stuff. Thank you.
We were half an hour.
So we're moving on to rules for public access to court records. And Judge Tomasi, did I pronounce that right?
Not even.
So sorry.
Tomasi is okay.
Tomasi.
All right.
Put a little note to tell me where the emphasis is on that. So, yeah, so we're looking at Rule 6B14, Judge.
6B14, we've been, I was here before, I think last, I don't know when it was, when we were promulgating this, and this one's actually one that's in the books already. We went through the process, had your comments from the committee last time, and I think this one is actually became effective over the summer. So
Yeah, were there any questions on this one? Because we can move this one along. Yeah, that was very straightforward. Thank you very much. And Rule 6B9.
This 6B9 is, doesn't change really the thrust of what the former rule was. This has to do with RFAs and stalking requests. And it's been a rule for a long time that the person making the filing, the complaint and the affidavit were considered non-public until the defendant had an opportunity for a hearing. And sometimes you grant or sometimes you deny those, and this kind of fleshes out what happens if you deny that request. The complaint and the affidavit and the denial all stay confidential unless the person requests that we have a hearing and that he or she wants to pursue the request for the relief from abuse order or the stalking order. Even though it was denied as a temporary order, you can still pursue it and try to get a hearing on that. So at that point, we tried to spell out a little bit about what happens when that happens. And if there's a hearing, then the denial sort of follows the old rule, which is the complaint, the affidavit, and the denial, the intent to pursue remain confidential until there's a hearing on it. Second piece has to do with the family rule had provided, Rule 9B provided that if someone provided their information for contact purposes, that we would keep that confidential unless they agreed for it to be public. So that was what Section B covers that. We had one comment that we received. I don't remember, Alan, if it was from you or from the Civil Rules Committee, either one. It was astute. The point was that Rule 80.10B, which is sort of the stalking parallel to the relief from abuse order world, has a similar provision. So we talked about adding that 80.10, adding the plaintiff for a stalking order as well, that unless the person requests that it be made public, it's going to be held confidential. And lastly, the Rule 9G family also has provisions keeping, if a defendant makes a motion, a similar parallel rule that the defendant can keep his or her address and contact confidential and for notification purposes. So This kind of illuminates that. There's one piece that we had at the very end of the reporter's notes, 15 VSA 788 has to do with information provided for child support purposes. So child support sometimes goes on and on for years and years, and Office of Child Support does some work to try to enforce those things. And they ask for addresses and phone numbers. And there was a provision of 788 talking about confidentiality. And we wanted to make sure that we weren't trying to loop them back together, that we wanted to make sure they were separate provisions. And so if it's provided under 788, the 788 provisions are going to apply to that. If it's provided under the RFA or the stalking rules, this is where you need to go to look to determine what happens with that notice and the address and phone number, because sometimes we have cases that go on for years and the RFA was 20 years old, but they provided an address in connection to a child support request. Then there was a question of which would control. So we tried to clarify that.
Right, okay. Does that need to be clarified in the rule itself? Is it sufficient to be in the reporter's notes?
I think our sense was that it was sufficient because it never referred to 788 in the first place. I think that the folks in the OCS were just wanted to make sure that, and the court staff, I think, wanted to make sure that there was no argument that this rule would somehow bleed over to 788. And so the reporter's note we felt was sufficient for that purpose.
Great, thank you. Any questions on this rule? I do not see any questions or comments. Thank you very much. Very straightforward.
All right, thank you very much, folks. Good weekend.
You know,
when you get there.
I was going to say.
Sunny out, sunny.
All right,
We'll take the rest of the day, but maybe not.
we're moving on to the probate rules, and we have Judge Kilgore joining us remotely, and we're going to start with Rule 18D, which should be very straightforward and getting closer.
We're catching up.
We're catching up.
We're catching up.
So
I'll
Judge,
do my best. Thank you for giving me the opportunity to appear remotely. Rule 18D was abrogated because in 2020, the guardian ad litem rules were brought from the family rules into the probate rules, and we missed the reference in 18D. And so we caught that up by removing 18D from the rules.
that seems pretty straightforward. So we'll move on to, no questions, I assume, on this one.
None.
Rule 5 and 6A4 and 79-1, filing and service by mail, which became effective on September 6th.
Chair?
Yes, yeah, I'm sorry.
I'm wondering if, with the committee's permission, if we could delay discussion of that rule for when we get to the analogous civil rule. And I would be happy to testify on that whole
Yeah, they're very similar.
package altogether.
Yeah, that would be fine.
If that makes sense.
That sounds like that will make us more efficient, so I'm all for that. So we'll, instead, we'll delay this, and there's a mirror rule that comes a little bit later that is whether we'll be talking about. So we can jump to one of our favorite rules, Rule 66.
Yeah.
Judge Kilgore.
Yes, 66 you've seen before. And if you have the paper copy, if you turn to page 2, top of the page, subsection D, in the version that you saw before, subsection D dealt with a requirement to submit information with respect to firearms. As a result of the conversation that we had with you folks and in reviewing some of the comments, we wrote that subsection entirely and took out any reference to firearms. And instead, we indicated that the inventory should include items of collections where the value is $5,000 or more. And then those collections, which could be firearms or Hummel collections or photographs or antiques, would contain specific items of description as the court thought necessary. And when we put the revised rule out for comment, we got just one comment instead of about 15, which was a lot for us. And that one comment thought that the inventory standards were excessive. And we had heard those comments the first time around, but we do feel that the information that we're seeking under the inventory standards is necessary both for the court to do what it's supposed to do in a state administration and to let the beneficiaries know what the assets of the estate are.
So Judge, so what you just said, I think is a response to a comment that was forwarded to us as well from Adrian Otterman. And I'll take that as what that was such, because I was going to ask you to respond to that and you just did. I appreciate that. Do you have more or should we go to questions? Because we have seen this before.
I don't have anything more to add with respect to that rule. I'm happy to take any questions.
Any questions or comments? I'm looking particularly at Senator Clarkson, who had questions and issues last time we took a look at
You're
this.
good to remember. No, I think I'm actually okay.
Okay. Excellent. Any other issues or questions on this one? Thank you for that change as well.
Yeah.
It was very helpful. Appreciate being heard on that. So I think we're good with that. It was quick and painless for you, Judge Gilmore.
Thank you very much.
Thank you very much. And now we are moving on to the civil rules. And Alan, and I'm going to try to get your pronunciation of your last name right. Again, I mess it up pretty much every time. Is it Kais?
That's right.
Oh, excellent. This has been a good day already. Thank you. Mr. Kais, over to you. And we're starting with Rule 50B.
This is a rule on preservation for appeal of claim of error on a denial of a motion for judgment as a matter of law. Our rule has been identical to the federal rule and interpreted in accordance with the federal rule, except back in 1988, we added this provision that you need to file the post-judgment motion in order to have a right to appeal from the denial of a motion for judgment as a matter of law. And that was there because that was what the case law was saying, but people were missing it. So we thought we would put the warning in the rule that you have to file you have to make the motion not once or twice, but also after trial. In the decades that passed, the federal authority has evolved, and it's no longer a uniform rule that in federal court that this last motion need be made. They've limited that requirement to cases where it's truly one of the sufficiency of the evidence, where you're testing the evidence against a standard, as opposed to whether the issue is whether you're testing what the standard itself is. So the court had a case where the party was testing the standard, and the court said, we cannot hear your motion because you didn't file it post-judgment because of the text of the rules committee. Is this a good idea? And this is our outcome, is basically to conform the text of the rule to the federal interpretation that the second or the post-trial motion is limited to sufficiency of the evidence questions, permitting the court to decide on its own whether to take the other kind of cases.
Right. I appreciate that. This one was a little more complicated, but I appreciate that explanation. It was very helpful. Any questions or comments on Rule 50B? I think we're good with that one. Thank you, Alan. If you move on to Rule 68.
This is an artifact of the pandemic. With the delay in jury trial, we're searching for ways to improve the delivery of justice in light of the delays. And the idea was to make offer of judgments available to plaintiffs so that while you're waiting for your trial, if you make an offer that's refused and your offer was better than what you, at least as good as what you ultimately got, you could collect costs of the ultimate that incurred since the offer was made. And it's kind of a minor provision because it only involves transfer of what are literally costs, not attorney's fees in most cases. But we decided there was, we decided to make it permanent, essentially is what this rule says, is to make Rule 68 available to plaintiffs as well as defendants.
So a quick question. So the plaintiffs before this rule, before AO 49, couldn't make offers of settlement? They could, but they just couldn't collect if they got less or more after trial. Is that correct?
Right. It's a cost shifting device. You can always make an offer, but if it's refused, there's no consequence unless you were a defendant under the old rule and you made an offer and the plaintiff didn't end up as well off as you had offered them, then the cost the defense incurred between the date of the offer and the ultimate trial could be recovered, would be deducted from the judgment. And so this is just a few wording changes, but makes it reciprocal, I guess would be the correct word.
And they incentivize some settlements that might otherwise not happen. So this could help with the efficiency of getting through our backlog.
Right.
Yeah, that was the intent.
Right.
I hope we're going to throw a huge party when we're caught up.
All right, any other questions on Rule 68, which seems like an excellent rule? I don't see any questions or comments, so we'll move on to Rules 7 and 8.
Yep. This was a small claims reform initiated by the Civil Oversights Committee, and there's quite a lot of detail in it. The one significant part is the requirement that the judgment be served before the enforcement steps are taken. In regular civil court, there's already a rule that says before you attempt to execute a judgment, a default judgment, it needs to be served. But in small claims, they have more frequently these financial disclosure hearings. And so they were concerned that people didn't have notice of the judgment and that these proceedings were unnecessary or got confusing unless the party were notified of the judgment. And at the same time, the rule is amended to provide certain paperwork be given to the defendant so they can know what the exemptions are and know what disclosures they might make.
So before, I apologize. I'm not sure if I'm looking at the correct rule here, and I'm wondering because the rule I'm looking at for 7 is assistance panels, and Rule 8 having to do with confidentiality.
We're in small claims rules.
This is 7.8, right?
Maybe I just have grabbed the wrong thing. This one said we look at what we have.
It doesn't say anything about small claims.
Yeah, I think that we might have the incorrect rule linked. I'm sorry that I missed that.
Can I email this to?
Assistance panels is what, it's Rule 7, assistance panels.
If I email it to you, Eric, can you forward it? Or?
Yes, and it is the wrong link. Apologies for that.
Yeah, I should have caught that yesterday. I just read the whole thing and
I missed it.
Well, link up to what the,
as it were,
things that, yeah. Well, it was Rule 7 and 8.
Yeah, right.
I figured that the agenda didn't have it right, not the other, but I don't know. All right, if we, why don't we, if we could skip this one just for now and jump to Rule 80.11.
Okay. This was a rule with a sunset provision initiated by the Vermont Bar with the support of the Chief Justice to try to get justice for medium-sized cases by streamlining discovery. It had a sunset. The sunset was extended, and this rule now makes the procedure permanent. Our investigation showed it's a very little used rule, but it's not doing any harm, and the people who do use it like it. So we decided go ahead and make it permanent.
Just a higher level question on this one, and is there anything that can be done that makes this kind of process used more often? You say it's very little used, but it would sure be nice if it was being used more. I mean, is there any way to incentivize, or is there any thought of looking at the rule to figure out how to make it more useful or used more, I should say?
So we
encourage its use.
We we conducted a VBA survey and invited comment, and we got, one comment was to change the title of the rule to make it more accessible perhaps, but we found that that was impractical for us. And there were very few comments other than, when I use this, I like it. I thought myself that sending out the survey, are you aware of this rule? Have you used it? Might encourage people to take a look at it and be reminded that it's there. I think my answer to the question is more education about the existing rule rather than any change in the rule.
Right, okay, all right.
And is that happening?
I don't know, I will take that up maybe with the Vermont Bar when we get them in at some point during the session to ask them about that. Any other questions on this one? We'll move ahead to Rule 25.
Emily, do you want to field this one?
Is this the one that matches the other, or is that? No, it's not.
No,
May I just
one before that.
tag on to that
I'm sorry,
question?
yes, sir.
No, I know we're way behind, but it does puzzle me that surely if we're responsible for creating the rules, we're also responsible for educating people about them. It isn't just the bar that's responsible for educating people about use of rules.
Right.
So, okay. So I think we have responsibility too here, not just the bar.
Sure.
Right?
Okay, yeah.
So what's our plan, when we say we're gonna do that, I'd love to know, okay, well, anyway, I don't want to delay us, but I'd just love to know what their plan is if they're on all these things that get changed. What is how do they then educate everybody about the changes?
Right. Is that, do you have any input on that or?
Maybe that's for Terry, I just.
More generally, my committee does conduct seminars to discuss rules and rules changes, and my recollection may be bad, but we may have done some of this, however many years ago when the rule was adopted, but certainly not recently. And as I said, when we authored this survey, part of our intent in framing the questions was to educate the bar that here is the rule, have you used it? Here's some highlights of why you might want to use it. But I think it is more of a DBA function perhaps than a rules committee function to do the education part.
You got it right.
Okay, so Rule 25.
Do you want to go back to the
Yeah,
one that you?
Yes, let's go back, I'm sorry, let's go back to Rule 7.8. I know we haven't had a chance to read it, but we have looked at it before, back in April, I believe. So we're backing up, Mr. Kais, to Rule 7 and 8. Now you should have it, it's been emailed to us.
Oh, yeah.
Just a moment ago, I sent it to each of you four. It was the easiest way to do it just now. So hopefully you all have it on your email with a link. And Emily sent to me, thank you.
I'm having a little trouble putting mine up, but from memory, Rule 7 is the financial disclosure rule in small claims. And what the amendments do is require service of a default judgment before there's a financial disclosure hearing held. And it creates an interval of additional time between the request, the opportunity for financial disclosure hearings. And at various points along the way in the process requires, in addition to service of the judgment, service on the debtor of the exemption forms and the disclosure forms. So that these proceedings end up more about the substance of what are the assets rather than someone not knowing what it's about.
So I guess a question, if you can recall, if there were any changes that occurred after this was presented to this committee
I recall some changes that were made, but I'm not sure in this process when they occurred. We received comments from ACLU and Legal Aid. And they requested that some language that was in other parts of the rule, I forgot, went from Rule 7 to Rule 8 or 8 to 7, but some parallel language was added to one rule from the other to clarify these the documents that need to accompany the notices.
Yeah, our minutes from that meeting reflect that you'd already taken care of the ACLU and legal aid's comments. So it sounds like that was incorporated already.
Right, yes. Yeah.
So we've seen this rule before. We didn't have a problem before, and I'm not seeing anybody having an issue with it this time. So we can move back on to Rule 25.
And Emily, here we are.
Good morning, everybody. I think we're still in the morning, right?
Happily.
For the record, Emily Wetherell, I'm the deputy clerk at the Supreme Court. And I just wanted to mention, I know we're short on time, but very briefly that Professor Kimben Roth is not here. And after, Alan, correct me, 50 years of reporter work, he has retired.
Oh.
So we will all miss.
Definitely miss.
We'll miss him.
His
It's always a treat to see him
at this committee. So I just wanted to point that out.
Yeah, thank you.
And how thankful we are to all that he's done for the judiciary.
Yes.
Thank you.
Out of time.
There are, I didn't count them up, maybe 4 different items on your agenda that are all interrelated. So I already asked the chair, Lalonde, here to defer talking about the probate rules. That's probate 5, 6, and 79.1. And then in the civil rule package, there's several appellate rules and civil rules. And I think some of them you actually have seen at a prior a meeting that you had. I think this one in particular, the appellate rule 25 was reviewed back in April. And the next item on your agenda there, the civil rule 5, 6, 29, the e-filing rule, and civil rule 79.1. So just as at this stage, I know that the court administrator is here as well, and AO 49 is on your agenda later, and there's already been some talk of AO 49, but I'm sure the committee remembers well that back in March of 2020, the court was looking, the judiciary as a whole was looking at ways that we could provide access to the courts given the constraints of the pandemic. And a couple of things came forward: email filing, email service, and obviously remote proceedings, although these don't touch on that really. They're more focused on the email filing and email service. At the time, we were just beginning our rollout of e-filing, as you guys have all alluded to already. So it was important both for attorneys and for self-represented litigants that they could communicate with each other and with the court by email. Since that time, the e-filing has rolled out in the whole state. So when I'm talking about filing documents by email with the courts, we're really just talking about litigants who aren't attorneys, so self-represented parties. And it's become very clear that this is a very preferred method of communicating with the courts is through email. I would say that a larger portion of documents coming into the court system are coming by email as opposed to in the regular mail. And so we really wanted to make sure that there was, that these provisions, once AO 49 sunsetted, that these provisions were incorporated into the permanent rules. And the Civil Rules Committee, particularly Alan Keyes, should be really commended for a huge amount of work that was done to try to put together very clear standards for email filing and email service and how that could be organized, and then also for coordinating with all of the other rules committees so that we could have some standardization around the state, so that if you're in Chittenden County, it's not different than if you're in Windham County, or if you're trying to file something with probate, it's not a different process than if you're trying to file something in the family division. Remember, this is all self-represented parties that are doing this, so there was a really strong feeling that we should have conformity throughout the judiciary. So if you look in particular at Rule of Appellate Procedure 25, basically the Supreme Court used to have its own rule about filing documents. And essentially, if you look at 25, a lot of it is just removing provisions of the appellate rule because instead there's a cross-reference there to the civil rule. And there was a subcommittee of the Civil Rules Committee that looked at the changes relevant to appellate. We had a member designated from the Vermont Bar Association to work with us on putting these rules together. I would say one topic of discussion related to the email filing and service rules, because they're uniform throughout and mostly it's in the civil rule, is sort of an ongoing discussion always when you're writing rules, and that is whether you should just cross-reference another rule or whether you repeat all of the provisions of that other rule in this rule. And as to the appellate rule, what we came to, there was a consensus to just cross-reference the civil rule instead of repeating it. There's obviously a liability if you keep repeating the same provision in several different places because you have to make sure that if you change something, you do it in all of those places. So in this case, we decided to just cross-reference the civil rule. So in particular about Appellate Rule 25, that's what that is doing, is incorporating the civil rule on email filing, on filing in general. So if you're looking on what you should need to do for filing in the Supreme Court, it's the same that you would do for the civil rule. Are there any questions in particular about 25? And then I can.
Any questions on 25?
Or Alan, did you want to add anything?
No.
All right, that one looks good.
So the next item is the civil rule. This is the package of Civil Rule 5, 6, 29, and related Vermont Rule of Electronic Filing 11C, and also Civil Rule 79.1. The civil rule is incorporated, you already just saw now, into the appellate rule. It's also incorporated into the environmental rules and into the family rules. And the probate rule that was earlier on your agenda, instead of the incorporation that I talked about for the appellate rule, the probate rules really felt strongly that they wanted to replicate. So the probate rule pretty much has exactly the same provisions of the civil rule, but it's replicated in the probate rules. I think they felt like for probate, they're very particular proceedings, and so you shouldn't have to have like 3 different rules available to you, looking at the probate rule and opening up the civil rule, then trying to, and there's a few language changes. So in the probate rule, instead of referring to the clerk, it refers to the register. There's a few different language changes, but really the Rules committees did a wonderful job of trying to come to consensus so that we could have uniformity.
Right.
So I'll just mention a few things that that whole rules package does. There was an update of some language. So for example, instead of referring to paper, there's a lot of, in these rules, it talks about paper, and we know things are happening electronically. So there's instead reference to document, and there's a definition of that. So that, you know, it could be something electronic as opposed to a paper that you're actually filing. There never was in the rule an allowance of email filing. So there's some nice definitions in there of what does it mean to email file. There's also an allowance in there for email service that's much more lenient than it used to be. So if you wanted to do service by email, and remember that this is not attorney to attorney. So if attorneys are serving each other, they're doing it through the electronic filing system. We're talking about a self-represented party serving a lawyer, or a lawyer serving a self-represented party, or a self-represented party serving another self-represented party. And what we heard from members of the bar is it's really hard to come to a written agreement, to get a hold of this self-represented party, to come to a written, what they had to do before was come to a written agreement that they would both sign, that they could serve each other by email. And so instead, there is an allowance in there that when a self-represented party, they file a notice of appearance in the case, there's a provision on that form that says, do you agree to service by email? And they can provide an email address right there on that notice of representation form and consent to email service. So then the other side doesn't have to contact them, make sure that it's okay. You've done it right there on their notice of appearance form, and they can provide the email right there. So that is both, the provisions related to that are both in Rule 5, and also that's what that Rule 79.1 is, the incorporation of the ways that a self-represented party files a notice of appearance in the case. In terms of discovery, what we heard from lawyers was that they actually preferred, so discovery is not something that you would file with the court. This is something that you would send to the other side, but you wouldn't be filing it with the court. And the existing rule allowed that to be at the party's choice, how they wanted to serve documents on each other. And what the members of the bar that were on the committee said is, we actually would prefer to get discovery through the electronic filing system. So I know that sounds funny because it's an electronic filing system. It's intended to be filed with the court, but you can actually use that system for service only. So instead of sending stuff into the court, you can, normally you would file and serve, that's what it's called, right? Odyssey File and Serve, but you can use it just for service. And attorneys said that they really preferred getting discovery through the electronic filing system because they knew that the correct email address would be used. If they had an admin that was working with them, that would also come through through OFS. So the change that was made both to Civil Rule 29 and then also in Rule 6 and in the Electronic Filing Rule 11C was that the default is service of discovery by e-filing, but the parties can agree on an alternative method. So it doesn't have to be a formal agreement. You can just agree with the other side. I'm going to put this in a Dropbox and I'll send you the link, and you can make that agreement. But without an agreement, the default is that it's service through the e-filing system.
Can I ask you a quick question on that? So by filing it on the e-filer, does that make it easier if there are discovery disputes, or is that doesn't really matter one way or another?
Yeah, thank you for asking that, Representative Lalonde. So that's another reason that people felt like they liked it through the e-filing system, because if I serve it on you through the e-filing system, I can actually look and see that, oh yes, it was sent. I can tell what addresses it went to. And I think you can even tell if it was opened, the email that went out, you can tell that it was opened on the other side. So it gives you a little bit of an audit of what if the other side says, oh, you didn't send it to my email address, you have a little bit of an audit there, like, yeah, it did, and here's the addresses that it went to. So that was another reason that people did also like doing it through the system as opposed to just by email.
Good. Great, thanks.
Alan, do you want to say anything else about discovery?
No, that covers it. You get a receipt basically, and you don't need a separate certificate of service, because the system, essentially the court is keeping the receipt that you served it. So it was preferred. I guess the other reason for doing is we didn't have to invent a pattern for how attorneys serve outside of Odyssey served by email, because that's going to be rare. So the rule is just for how pro ses are served by email or services received from a pro se. So the drafting was made a lot easier to put everything through Odyssey for service between lawyers, and we're just focusing on self-represented litigants in Rule 5 now.
So maybe I should mention, in terms of email filing, for self-represented parties, it's really at their discretion, and they can choose how they want to file with the court. One day they could send something to the court by email, the next day they could decide to put it in the mail, or they could walk into the courthouse and hand in a paper. So it's not like they're required to say, like, I'm going to email file everything, or I'm going to, they don't need to choose one or the other. They can do whatever they want. If they do choose to be an e-filer, the e-filing rules, once you elect to file in a particular case, you have to continue to do so until you ask for permission to not do that. And that's because in the e-filing system, that's how you serve the other side. So the other side has to know, if you're not going to be an e-filer anymore, to not serve you through that system. But if you don't engage in e-filing at all, then as a self-represented party, you can choose how you want to file with the court through any of the other means. If you do email file, there's a few requirements there in the rule. You have to send it to the email account for the court that it's going to. You have to put the information as to what court you're filing with, preferably a docket number. It has to be an attachment as opposed to just something in the body of the email, and it needs to be signed, but it's sufficient to just use a /S or other kind of electronic signature. I think Judge Morris mentioned before when he was talking about the analogous criminal rule that one change that was made in the permanent rule as opposed to what was in AO 49 is the effective filing date for an email filing. Under the e-filing rules, an e-filing is effective today if it's filed before midnight. And under the temporary rules that were put into effect under AO 49, email filings needed to be filed by 4:30 to be considered filed today. And the committee really felt like there should be parity there. And so if you're filing by email, it will be considered filed today if it's received before midnight. So that if whether you're a self-represented party or you're an attorney filing through e-filing, you still have the benefit of being able to file after hours.
Key extra hours.
Yeah. Hopefully we don't all take advantage of that and we can be done our work earlier than that, but it does allow you to do that. So there was some changes made in the rule to identify what is the effective filing date for different types of filing and to give the email filers up until 9. I think I've touched on the main points of all of those rules. I don't know if you'd like me to go into them more in depth, but I think that is a pretty good overview of those.
So that was great.
If there's any questions.
That was a great overview. And that's the same for the rules that we looked at or skipped over. I don't think you need to go over that except for that.
Yeah, probate is really the same, although the language is replicated in the probate rule, there's nothing really as to substance different about what the requirements are there.
Any questions or comments on those two rules? Well, two packets.
Maybe 4, yes.
Two packets of rules, I should say. I don't see any. I think we're good on those, and that brings us to probably another one that looks very similar to something that we looked at earlier, and that's Rule 6.
Yeah, so this is, make sure we're in the same place. I'm on item 16, is that?
Yes, item 16, yeah.
So item 16, also you have already looked at this before, and Judge Morris mentioned this when he was talking about the criminal rule, that we have finally ended the 3-day rule, the infamous 3-day rule. The 3-day rule allowed you 3 extra days to file certain kinds of documents with courts. It was originally implemented in the federal rule on the recognition that sometimes a party is required to file something based on the date that they received something from the other side, and that it might take 3 days for mail to get to you, and therefore you needed this 3 extra days. The federal rule has severely limited this. It no longer applies to things that are e-filed or sent by email because there's not that delay. And it has, I have to say, from a administrative standpoint, it's extremely confusing to self-represented parties when the 3-day rule applies and when it does not, and probably to many lawyers too. And so for purposes of counting, and I'm sure you all remember our wonderful day is a day counting rules, very close to your heart. The 3-day rule adds additional confusion onto the day is a day counting. And so the 3-day rule now has been abrogated across all divisions. The group that we had working on appellate issues really felt like if we were going to get rid of that 3-day rule, that that there should be a consideration of extending the time periods for filing appellate briefs to conform to the federal standards. So that's what the feds did. They got rid of the 3-day rule, but they increased the time periods for filing briefs on appeal. And so those two things were done in tandem, so that the appellate periods were increased and the 3-day rule was abrogated. Are there questions on that one?
Questions? No, I think we're good on that one as well.
Okay.
So we're moving along here, cruising along. Rule
You want to do
26? Yeah.
Yeah.
Oh, back to another 20.
This one, this amendment involves the duty to supplement. And the primary change is adding a duty to supplement expert disclosures. I've kind of lost my audio. Can you hear me?
Yes, we can
Okay.
hear you.
The example given that prompted us to look into this was an attorney deposes the other side's expert. He finds all the holes in the methodology that he used or the studies that the expert used and goes to trial ready to cross-examine, only to discover that the expert has done completely new studies and has come to the same opinion, but through a different means. And this new information has never been disclosed. The federal rules would require disclosure of new opinions, whether in response to interrogatories or automatic disclosures that they have in federal rule, or opinions given by the expert in a deposition. So that language in E4 requires supplementation of expert opinions. In the process of opening the rule, we found that it had departed in 2 or 3 different ways from the federal rule, and we deleted some language that could be used to make the rule mean what it wasn't intended to mean. We deleted completed when made and thereafter acquired to make it clear that if your request is incomplete when made, you have a duty to supplement and you have a duty to supplement if you had the information at the time. The inference that probably never was made, but that language is not in the federal rule anymore and is unnecessary. Then the final change is we added in a timely manner. Somewhere along the line in our amendments of this rule, the timing requirement got omitted, I think inadvertently. On the federal side, they used various reasonable time or at appropriate intervals or in a timely manner in different time periods and different sections of the rule, and eventually settled on, for the most part, in a timely manner. So we decided to use in a timely manner and with reporters' notes that guide people to understand you don't have to constantly review your discovery to see if it's accurate, but to do so in a timely manner before some event that's coming up, like a mediation or a trial or a deposition. You can't wait to supplement till after that event has occurred. So, those changes, I think, went through without any public comment. I mean, without comment from the public after our comment period.
So is there any case law on what a timely manner is in these circumstances?
Yeah, I'm sure there is. I know there is, but what I'm more familiar with is the federal reporter's notes. There's quite a lot of learning in the federal reporter's notes about what the meaning is, and particularly the notion that it's not a constant duty to supplement, to be looking at your previous answers to make sure they're accurate, but it's a duty to look when as I said, when something's coming up where it's going to be needed in the case. What I would say, the golden rule, if you would want your opponent to supplement, then you should be supplementing under those circumstances.
Great, I appreciate that. Yeah, I guess I was a little surprised that we didn't already have this, but were there any questions or comments on this rule? I think we're good with that one.
Yeah, that may be a stretch. That we're good.
Well, I'm good with that one. So rule 33.1 and 34.
I think that's me. These are appellate rules regarding oral argument at the Supreme Court. And just for context for the committee, the Supreme Court only hears legal argument on cases. There's no evidence presented, so no witnesses, no jury, no taking of any kind of evidence. These are just legal argument. And when the pandemic began back in March of 2020, we very quickly turned to remote oral argument, as did most of our sister states. And I can remember well having to get that up and running on a very short time frame. The court was very concerned about public access to the arguments. And so since the very beginning, when we were doing remote oral argument, we have provided live streaming to all of our oral arguments to adequately provide public access to those arguments. Almost all arguments at the court are open to the public. their public hearings, even in cases that are confidential in the trial courts. So there was a subcommittee put together on the appellate stuff. Actually, I shouldn't say that. I don't think we looked at the oral argument rules. The rules did go out for comment back in April, and essentially what the rules do is they set a default of remote oral argument for cases that are screened for hearing by a 3-justice panel. So the court's docket is divided into cases that are heard by a 3-justice panel versus cases that are heard by the full 5 members of the court.
Can I ask a question on that?
Absolutely.
So the court determines what's going to be a 3-panel. That's not a request by litigants. It's a decision by the court's office or the court in some manner?
Yep, there's a rule that governs what kinds of cases can be heard by a 3-justice panel. And the court makes an initial determination of that. Litigants are always free to file a motion for full court review. And there's a list of factors that should be considered in deciding whether or not something's heard by three justices or 5. Under that rule, there has to be unanimity amongst the 3 justices, so that if there might by necessity be heard by the full court if the 3 members can't agree on the outcome of the case. So those 3 justice oral arguments are just 10 minutes, 5 minutes aside. And the way that the rule is written is to default those to a remote oral argument. There is provision in the rule that you could file a motion for an in-person hearing if you wanted to do that. In contrast, the full court cases are defaulted to in-person hearings, and they can be remote by motion. Rule 9 is also included in this package. It didn't go out in that initial comment period, and there was a comment that came back from the Criminal Rules Committee saying maybe you should clarify in the rule regarding bail appeals how the bail appeals are heard. And there actually were existing provisions we have a few different kinds of bail appeals that allowed bail appeals to be heard remotely. Bail appeals are done on a really quick timeline. Obviously, we need to turn around those appeals really quickly. And often it's the local state's attorney's office or local public defender's office that is arguing those cases. So you can imagine if you're a public defender down in Windham County, it's really a burden to come all the way to Montpelier for a bail hearing in the middle of your very busy day. So we have actually, even pre-COVID, historically done those bail appeals remotely, primarily by telephone in the pre-COVID world, but now we have that ability to do it over WebEx. And so the bail appeals, there's a small amendment in there as well to continue that practice of doing those remotely. So are there questions about?
Any questions or comments? Great.
Provision. I think, Alan, do you want to do you want me to do civil, the small claims and judicial bureau?
If you will.
Okay.
So this is.
Is that okay to move on?
Rule 6 and 80.6.
Okay.
Yes.
So again, in keeping with our theme of this day, these are permanent rules that implement provisions that were in AO 49. This rule, it's a small claims rule 6, and 80.6. 80.6 is the rule on the civil rule on the Judicial Bureau proceedings. And basically what the rule is doing is incorporating the small claims rule, and the small claims rule allows remote hearings. So since March, I guess April of 2020, the Judicial Bureau has been conducting remote hearings, and that has been very successful in that docket, as I understand. And it was provided for in AO 49, so this was a permanent rule that was put into place to allow the use of remote hearings in small claims and in the Judicial Bureau proceedings.
Great. Any questions on those? Nope, straightforward. Thank you.
You want me to do eviction foreclosure or?
I was thinking I would do that.
Great.
The eviction and foreclosure special procedures 9.2 and 9.3 are new rules that are based on the temporary rules that went into effect under or procedures under AO 49. We realized last spring that there's going to be a need for more permanent rule longer than AO 49 would last. Primarily, these rules govern evictions and foreclosures where federal money is available to pay banks and landlords and for tenants or mortgagors who are behind because of the COVID problem. And a lot of money has been spent. The rule provided for notice of these programs to the defending parties and opportunity for the court to stay proceedings while the application is pending. In the process, both these rules are going to be sunsetted on the date the federal appropriation expires, which is, I think, sometimes in the year 2025. But the funds have already run out on the rental program. So we no longer have a provision for notice of the rental program because they're no longer receiving applications. But there's a continuing provision that if there's a pending application, the court has discretion to take action to wait for the application to be acted on. And in the mortgage foreclosure rule, we regularized the rule a little bit to provide a motion procedure for shortening the stay or lengthening the stay. The one major thing we did different from AO 49 was AO 49 had an automatic 60-day stay. And in this case, we adapted the choice of the legislature in tax appeals, making the stay extend until the application had been ruled on. So we basically, it's a longer stay that's automatic, subject to the right of the bank to come in and say, no, we should shorten it. Those are the provisions about the funding. There's an additional provision on the for residential rentals involving the CARES Act, in which Congress said there's certain tenancies that are associated with federal money, federal loans or federal programs. The statute had a moratorium on evictions, but it also had a moratorium on sending notices of termination and a statute that requires notice of termination be 30 days, any state law to the contrary notwithstanding. The Rule 9.2 continues the requirement that the plaintiff in the case disclose whether they have this federal connection and whether or not they've made the required notice. The one issue that came up was whether the federal law extends to all evictions or only to residential evictions. And we went kind of back and forth on this, but ultimately decided that the statute isn't totally transparent on this. There's case law that says it's limited to residential evictions, although I'm not sure that's dispositive. So what we did was limit the rule to residential evictions, and in the reporter's note say we take no position on whether whether the CARES Act might have broader applicability. Both these rules, I expect the mortgage money, I'm told, we're in contact with the administrator of that system, might not last through next summer. So we're going to keep our eye on that to see when the funds expire, we may have to make some changes to the rule.
Senator Clarkson.
So I'm just curious, you talked about the eviction being tied to the application and not the funding. So as we work to find more fundings and create a softer off-ramp instead of a cliff for these people, are we going to extend, is the eviction moratorium going to both for foreclosures and for rental evictions? Is that going to parallel our work that we're doing as we try and find more funding? So it will be extended and go lockstep with our ability to make it a little less difficult for people? I'm not quite clear on how I'm asking this question, except that as we find more funding, we're hoping that there'll be a softer land for people whose funding may be, we don't want people evicted as they try and figure out what to do, given we have no place to put them in the state.
Both these rules are tied to specific federal programs, and if the federal money is gone,
it's not
the rules do not apply.
But we're in the process of finding other pieces of federal money to supplant what the uptake, which was more than we ever had anticipated.
So let me just say, I mean, so if VRAP and VHAP are continuing, however the funds are, it would seem under the rules that these rules would continue. It's not necessarily tied to the funding, it's tied to the program. Is that right?
It's tied to the source of the money, I thought was what you said. The federal money versus state money.
That's my understanding. I know the rental program, I know other monies have been found. The rental program is continuing. There are other ways to avoid eviction through either state or federal programs. This specific rule is only covering the specific federal funded program. And if there were to be other programs that need attention, we should be alerted. I know that legal aid, as I said, the applications were closed for the rental program on October 1.
I'm clear on that. What may be happening is more federal money is being found that has not been spent yet and put into that program. So what you're saying, and it's, I think, giving us comfort, is that as long as that program is funded with federal money, the eviction stays will continue.
Right. And I've been assured assured that legal aid is what they're doing is, the part of the rule we eliminated was the notice that here's notice that there's a federal program, there may be money available, that the administrators of that program said, we don't want the court giving notice for a program that doesn't exist. We're not taking applications. So, but what legal aid is doing is every week they're downloading all the new eviction suits and they're giving individual notice to all the defendants of where they can get legal help and where they can get financial help. And if it is within this renter's program, then the rule does provide the judge an opportunity to hold things up while the application is pending.
So in Rule 9.2B1, that's not tied to the availability of money. That's tied to however long the CARES Act has this requirement.
Right.
Is there a sunset or time frame for that requirement under the CARES Act?
No, people were surprised that it didn't have a sunset, but it's a standalone provision that continues, as far as we know, unless Congress amends it, will continue to require 30-day notice in these federally connected properties. And as it affects us, you have a statute that allows shorter notice in certain specific instances. For example, criminal activity or drug activity is, I think, a 15-day notice. And if it's the federal law supersedes the local 15-day notice requirement where there's a federal connection. And we're just going to have to keep looking at it to see if Congress changes it or not.
So one last thing I think on this is that we will hear probably no later than or I should say this committee, whoever's on it, will hear no later than sometime next summer the status of this from what I understand.
Right.
Any other questions or concerns on this particular rule? I think we're good with this rule, and thank you very much, Alan, for your time and your effort on all this. This is great.
Thank you again for the day as a day effort.
That's really has been my number one accomplishment of my 8 years in the legislature, is working on that one.
You should be proud of it because we now got rid of that little pesky 3-day rule, and time counting is easy.
Excellent. That's what we're trying to ease this out. So, all right, and I apologize, we're running so late, but hopefully we can hear from Terry. So
Want me to stay up here too? I think you're welcome to, but I don't know if you so nicely covered everything regarding most of what I was going to talk about.
Well, it's just a treat to have you.
Yes, yeah. So how long have you been on the new job? Has this been like 6 months or something?
We started July 1.
July 1?
Yes.
All right, well, congratulations or condolence, I'm not sure. So we're looking forward to working with you.
Well, it is so nice to see you all. And for the record, Terry Corson, State Court Administrator as of July 1, I guess. But thank you. And I know I was supposed to talk about AO 49, but it appears that you've been talking about AO 49 since 10 o'clock. I'm happy to kind of give a little summary, although Emily basically, she also nicely sent me some questions that had come up that I'm also happy to answer those if that would be helpful.
I have a question about when we're going to get caught up. When do you anticipate the court is going to get caught up?
Well, with the backlog. So certainly, actually, even before the pandemic, there were backlogs in the court. And that was due mostly to short court staffing and judge vacancies. But the pandemic certainly exacerbated the backlog situation in the courts, primarily certainly in the criminal division. And I know the governor's action plan speaks to backlogs in the criminal division. When jury trials were halted for a year, that caused a huge backlog because as you're aware, jury trials in particular and hearings in general really move cases along. They don't move, and they didn't in the criminal docket and in the civil docket too, because jury trials were halted there as well. So the kind of the lockdowns and the restrictions that prevented people from appearing in court really caused a huge, basically many cases grounding to a halt. So that has helped in this, or that situation has been improved because we now have the courts open. A couple of things made possible what movement did occur in the courts, and that was remote hearings. Before the pandemic, remote hearings were used very infrequently. And if they were, it was by phone, which was unsatisfactory and inadequate. One silver lining of the pandemic is we received a huge amount of funding, pandemic funding, that enabled us to purchase and install the equipment that allowed us to carry on remote hearings, which was a huge plus. And right now, we're in the process of figuring out how to best utilize that new tool that we have that we didn't before, and what's the right balance of in-person versus remote hearings going forward. But the other things contributing to the backlog were staff turnover, like the workforce in general. We had a lot of retired people who retired, or a lot of turnover in the workforce. Another aspect of it, as you recall, we started e-filing and the new case management system right at the very start, March 2020, to try to have as much stress as possible all at once. That actually, there are efficiencies that resulted, and thankfully, for example, one is the electronic file where judges could work remotely and access their files remotely. But it slowed things down in terms of trying to process things and the training. Now it has been all implemented, working on making improvements in it, but that was a slowing factor as well. And remote hearings themselves, even though they did allow us to carry on, remote hearings oftentimes took longer than other hearings. If you can imagine, like in a meeting, you have somebody who loses their connection, or the screen freezes, or somebody can't connect. Things just took longer. We couldn't schedule as many hearings as possible within the same hearings. So it was kind of that variety of factors that led to the backlog. But I feel like we can have many things in our rearview mirror now. We don't have the same health and safety restrictions at the courthouse. We don't have the isolation distances. Masks are required. Many of the courthouses now, there are only 2 left that still have some HVAC work that's needed to be completed in January. So we can have more people, bigger capacity in the courtrooms and in the courthouses. So we've actually implemented, in terms of the backlog, a judiciary backlog plan that asks for each unit, understanding that each courthouse is, has unique circumstances, would be best positioned to say what would be our best way to tackle this backlog, whether it's scheduling changes, whether it's staffing, whatever the situation is, we've asked them to analyze it and to move forward. We've provided some new scheduling parameters that allow cases to move more quickly, to be scheduled more quickly, with the goal of having a next event set in each and every file, the thousands of files that are out there. We plan to use retired judges, retired court staff, knowing that scheduling hearings, especially jury trials, is the best way to move cases. So that's where we are in terms of, we're also advocating for increased staffing, because we found that it takes more people. When you're running a courthouse or courtroom remotely, you have the court clerk who's normally doing the inputting for the docket entries, also doing the audio recording, also doing the video recording, also checking people in where they're, so it takes more manpower to accomplish the work that needs to be done. The other thing is expungements. Everybody's in agreement with all the value and benefits of expungements. 3 court staff full-time are dedicated to expungements. Those are people that aren't able to do the processing that they were doing otherwise. And we have, there's a lot more expungements to do. So that was kind of a stress, I guess, on the court staff. So with that, we're going to the legislature to ask for the staffing that are necessary to allow us to even operate, let alone work on the backlog. But that's what we're doing, step by step, day by day, doing what we can. It's been a huge plus being able to schedule the jury trials in full force. For example, I think it was in Orleans yesterday, they had 13 cases scheduled for jury trial, they all settled. But they don't settle until there's a jury trial day. So we lost that kind of incentive for all those months and for that full year. But that's how we're working to catch up.
Good, so it sounds like we're gonna see a big, well, it'll be interesting to see the judicial budget when it comes. We hope it will be full of what you actually need.
Well, that would be great. The other thing that we're doing too, we found out in the transition from the old system, VTADS to Odyssey, in the data, that there were a number of errors in the data, that we're also implementing a data cleanup plan, because your backlog numbers are based on the data. How many cases are older than the prescribed timelines? But if the data on the cases is inaccurate, then you run the risk of having inaccurate backlog numbers. So we're doing a data cleanup plan, and we're also looking at the dispositional guidelines, because those guidelines, many of them were 8, 10, 12 years old. And we found out nationally, the guidelines typically are not attainable. They're aspirational, but many times not attainable. So we're looking at them, and we're actually surveying judges now and court staff to ask what are realistic timelines. And we're as part of this backlog plan, establishing realistic guidelines. Because if you're meeting realistic guidelines, that's one thing, that's great. If you're not meeting realistic guidelines, then you need to ask why, and what changes do we need to make so that you can. But that's another aspect of it that, came to light, that we really want to work with realistic guidelines versus ones that are completely unattainable, I think get ignored then. And it's demoralizing if you're working, like crazy and no chance of meeting these guidelines. So that's another aspect of it. Do you want me to answer the other questions that came up just briefly, just so you have? I know one was Senator Ram asked about the WebEx video being provided to a defendant, but that must have been a misunderstanding, because that wouldn't be possible. We don't record the WebEx video. There is an audio FTR recording that's available, on request through a process, but not in video. So I just wanted to clarify that. And she'd also asked about translations of documents, and there is a whole team in terms of the translations. They have in alphabetical order, Arabic, French, Nepali, Somali, Spanish, Swahili, and Vietnamese translations of what of key documents, RFA documents, stalking documents, applications for applications to waive filing fees, applications for public defenders. Those documents have all been translated, and there's a process that if somebody needs a vital document in their court hearing, there's a process for that to happen, for that to be translated into their language. So I just wanted to make mention of that. And Senator Clarkson, you had asked about e-filing and the status of e-filing.
Our favorite subject.
Well, I am proud to and happy to report that way back, if you remember, when there was a report that was given to the legislature after the e-filing fee adjustment was made for ways for court users' input into e-filing questions or concerns, a change advisory board has been established for that specific purpose, to look at how to improve e-filing, how to improve Odyssey. And the court users group that was developed that involves members of the BBA and other court users, they're a consultative body to that change advisory board. So there's an every 2-week process where they can provide change requests, and it's evaluated. And then I know some at least have been implemented. Some, if there's a reason why it can't be, whether it's cost prohibitive or whatever, there's at least a mechanism to go through them and have them addressed. So that.
Yeah, Walter talked about the permanent group that had been put together.
The court users group, yeah.
So also, I think he mentioned a group that's looking at any other kind of rule changes based on AO 49 and the learning that we've had. If you have a comment on that.
There's a special advisory committee on remote hearings. Is that perhaps?
That probably is one.
Is they're studying the rules that have been suggested, because our rules before for remote hearings were very kind of basic and primitive because it wasn't really used. Now with everything we've learned about remote hearings during this process, there have been amendments proposed that will address whether it's a remote or an in-person or a hybrid hearing, and to try to make it I guess, streamlined and easier. The idea being that some type of hearings might default to remote. For example, status conferences, where they might last 5 or 10 minutes. And if you can prevent somebody from driving an hour or from somebody having to take off work to be there, for those kind of make sense to be remote. In person, oftentimes the distinction is based on whether it's evidentiary or not. Because if there's exhibits or documents, it can be done remotely, but it's more cumbersome, and you have, the possibility of issues with that. So evidentiary hearings, certainly jury trials in person, but trying to figure out what the balance is. And then if it does default to remote, that there always be the option to ask for participation in person in the reverse. So that's kind of in a nutshell, but they're looking at specific amendments to all the rules that impact remote hearings to make sure they are changed in accordance with what we've learned during this time that really has been almost revolutionary, just in terms of access to justice. Because you certainly have people who are able to participate much more conveniently and inexpensively than they could before. And lawyers who can now represent people in the far corners, that there might not be attorneys in the area, but they can represent them remotely. Or the attorneys that are doing, for example, multiple juvenile contracts. Whereas before they'd have to drive to one county and that would be it. They can now go from one county to another remotely and, do that much more representation. So it's definitely had, a silver lining, and we're just trying to make sure we find the right balance to make sure we can use the tools where they can best be applied. So that's what we're working on.
So just one last question. So I know in the past we would get a status report of how the courts are doing at the end of every year. I don't recall having seen it the last couple of years. It looks at throughput and those kind of things.
Statistical report?
Yeah, I assume that something like that will be available by the end of the year. And are there any other status reports that would be helpful for anybody kind of getting prepared to look at this issue next session? And if you think of anything, if you could send them along.
Oh, great. Yeah, they're working on the annual statistical report right now, for example. And then also just a report, which I think in the past has been kind of heavy on an overview of the judiciary in general. We're working on what I'm calling the static report. That's kind of true year to year, which is, I think, very informative and especially useful to new legislators.
Yeah.
But that's kind of the static report. And then I envision this annual report that's saying, here's what the highlights are from this past year. Here's what was accomplished, here's the data, and then what our goals are for the next year.
So we'll have an updated static report.
Yes.
This session. Yeah.
Something that was on my mind, and I'm not sure if it goes along with that or not. I was just wondering what the effect that misdemeanors are having on the court system right now.
Do you mean like the number of misdemeanors?
Yeah, the number of them and how soon you project to get caught up on them and that type of thing. And more specifically, and I'm sure, I know you don't have the information in front of you, is people who have nothing on their record except maybe one misdemeanor or two misdemeanors, because we did talk about it last year a little bit because they were building up through COVID.
Oh, you mean in terms of expungements, if they have one or two misdemeanors? Or?
Well, there was a little conversation around it, not that we did anything with it, but.
Oh, okay.
Wasn't it, I mean, that felonies were really the priority for jury trials and such, and misdemeanors were kind of, is that?
Right.
That's what I recall, part of the discussion.
Right, yeah, and misdemeanors weren't getting taken care of.
Well, yes, certainly. They kind of prioritize the oldest cases and then the more serious cases, feeling that it's more critical with a limited jury trial. Judge Zoni would be the best person to respond to that, but I know that in each unit, they're kind of prioritizing, they're looking at their cases, oldest first, and then prioritizing. But now, again, that since jury trials can be scheduled, a lot more are dropping off because just being on the list motivates, settlement. So, but I'll ask Judge Zoni in particular about misdemeanor numbers, that distinction, because I know.
Because if I remember right, there was a time frame put out at one time that to get caught up, it was going to be like 6 years to get misdemeanors, which seems kind of ridiculous to have a misdemeanor hanging over somebody's head for 6 years.
Right. Yeah,
Was it 6 years? It seems like it was.
Yeah, I don't remember exactly.
Crazy amount of time anyway.
Yeah, well, I know now that, again, we're back in person without the HVAC limits. Before, we could only schedule so many at a time because of the isolation distances and the capacity of the courtrooms. Now that we're back to where it's not so much, we can schedule a lot more at a time. And that, again, would result in more of them dropping off than if not.
Great. Any other questions? Thank you so very much for your patience and waiting.
I learned a lot and it's so
Great to have you.
Thank you. And I guess when we